Welcome to Domestic Violence Connection Circles, supporting victims through COVID-19. Every Monday, we talk about different facets of domestic violence and try to raise awareness and knowledge about rights, about why domestic violence is rising in the pandemic, and about just, giving people resources, awareness, and knowledge, because ultimately knowledge is power. And tonight, I am very honored and thrilled to welcome our two guests, Michael Stangarone and William Abbott. Both are very established family lawyers with years and years of experience, and they will be talking to us about family law, especially as it pertains to domestic violence, and just raising awareness in some of the gaps of knowledge that they see out there. So welcome, William, and welcome, Michael. Hope you're both doing well.
Thanks for having us.
Thank you. Thank you for having us.
Thank you so much. So I'll dive right in. I've been hearing this a lot over the news in the last few weeks about how domestic violence is rising during the pandemic. And I did a session on this 2 weeks ago where I talked about some of the reasons why that seems to be happening, which is isolation, lack of financial control on part of women and on part of victims, and shelters and resources being full. But what are some of your thoughts, especially from a legal background and what you've seen over the years, how domestic violence and lack of this knowledge of your rights and awareness really melts together and makes the problem a lot worse, especially during times like these when traditional support systems and awareness vehicles are not quite available the way they should be?
Well, I think there's a misconception in the public about what's happening with the courts, because I think there was a Globe and Mail article that said that the courts are closed. But the courts, they've suspended regular operations, but that doesn't mean that they're closed. I mean, I've had, I mean, there's a COVID-19 protocol in place during this pandemic that while the regular operations are suspended, parties can bring urgent motions to the court. A motion is basically to ask the court for relief, temporary relief during this pandemic by way of conference calls. So I've had a few of these, and two in particular with the Brampton court, where victims of domestic violence were accessing the court through this protocol to seek assistance. And I agree, I've heard that domestic violence is on the increase during this pandemic. I mean, in the one case, my client was in an abusive marriage and had to flee with the kids to a hotel, like pre-COVID-19, when hotels were still around. But because of COVID-19, she received a notice because she couldn't afford to rent or anything. He wasn't paying support. This is an example of financial control in addition to emotional and physical abuse. But she received notice that the hotel was closing, so she had to leave. So under this protocol, you first have to request a date. You have to prove urgency first to get into the door, and then you argue the motion. So in that situation, we were able to access the court because the court agreed that, I mean, she would have been, she's the primary caregiver of the children. She would have been out on the street because the hotel was closing. So in that situation, the court found urgency and allowed our client back into the home. So we saw the relief was exclusive possession, meaning of the matrimonial home, that both parties have an equal right to possess the home under the Family Law Act, the Ontario law. But in certain circumstances, including circumstances where there's abuse, you can seek what's called an exclusive possession order, where one spouse will be permitted to possess the home exclusively, to the exclusion of the other spouse, who then has to vacate.
Yeah. And now that, you mentioned this, like at that time, hotels were still open, but now that's not the case. A lot of hotels are closed down and a lot of shelters are full. And in this case, there's this rising panic around what to do. In fact, a couple of weeks ago, I was exchanging messages with a woman on Twitter who was just like, I'm calling every shelter, and every shelter in GTA is full. I don't know where to go. And just today I was talking to a friend of mine who runs a shelter, and she's like, we are experiencing 50 times the number of calls that we normally get. And it's just a lot of women are just reaching out to us. They may not be in need of immediate housing or immediate shelter, but even just for awareness, even just for supports and the peripheral supports that shelters provide are often tied to women being there. So that's such an important point. And William, I'd like, if you could maybe just get into a little bit about overall, just a general overview of how domestic violence factors into family court decisions. Like, family court decisions are already could get quite tenuous and adversarial, even when there is no domestic violence involved. But when there is, and a victim is afraid of being confronted with her abuser in court, or she's just intimidated and her confidence is super low. I remember in my time that was certainly like I was very intimidated by the whole court process. Maybe it might just give people who are listening a little bit of a comfort to know that courts do take domestic violence into account, and how do they do that?
They do. Samara, thanks very much. You raised one point earlier and you said knowledge is power. And that is so key. And when you ask about why things are on the rise, I think it's partly because people are being isolated. And if you're in an abusive relationship, it's quite possible that the spouse doesn't allow you unfettered access to your cell phone, unfettered access to friends. You can't go out and speak to them. So you're at their mercy. And you're stuck in a home now where before, if they were going out to work or run errands, at least you could then sneak in a phone call here or there. But what you have to remember is that abuse is considered any unwanted touching. And it doesn't necessarily just have to be physical abuse. A lot of people say, well, he hasn't hit me. It doesn't have to come to that. There is mental abuse that is quite common. So, and a lot of people also are under the misconception that the courts operate like that TV show Law and Order. You've got to get on the stand and you've got to give evidence. That's not the way it works. Right now, in fact, what the courts are doing is you do everything by telephone. And in many cases, a judge just wants to see written material. And so it's a matter of telling your story, and it gets laid out in what's called an affidavit. And our office is still open for business. The meetings happen virtually. We don't actually meet in person, but we commission documents so you can swear your statement. And it's quite efficient. It's easier than somebody coming to one of our offices. They can do it from their home, from on their phone. And I also find, and I think Michael will agree, sometimes it would take quite a while to get into court. It might take a week or two. Matters are literally being heard the next day because there is not a huge delay, and not a lot of people are as versed in getting into court as we are. We're one of the biggest family law firms in Ontario, if not Canada, and there's about 45 of these cases that have been decided under this COVID-19 protocol. I would say we probably have a third of them from our firm. But getting back to your point, you swear an affidavit. You also swear it's called a Form 35.1, which is an affidavit in support of custody. And a judge bases his or her decision on that information. But it's written right into the Children's Law Reform Act and the Divorce Act. It says you have to consider any domestic abuse. So it is a factor when determining everything from exclusive possession, which Michael just spoke about, to parenting of the children. And there's also, you can also look at financial abuse when people are being starved out of money, like the case that Michael said. And in a case that I did last week, and it was an emergency, I managed to get $25,000 for the wife right away because she had no money and he was holding all the purse strings. I'm going to go to court later this week. Husband missed a payment. He's not paying child support. We know the money's been paid into court, so we're going to get a substantial sum paid out. But I know that Michael and myself, along with the other people at our firm, are happy if you email us with questions and we can set something up so that you're aware of what your rights are. And your rights have not changed during this pandemic. Your rights still remain, that any abuse is considered unacceptable.
You mentioned such a great point there, William, that abuse is not just physical, right? And I work with a number of different organizations across Canada, and Assaulted Women's Helpline. I was having lunch with their ED once, and she said, the highest number of calls that come to us are women who are reaching out to us and saying, hey, he's not hitting me. Is this really abuse? Am I actually being abused? It doesn't feel right, but it's not like I have bruises on my body. So how can one even portray or sort of put the case out in family court that there's abuse going on if there is no physical evidence, if there is no report? Because if and first of all, do you need to report? Let's say if there is physical abuse, do you need to report in order to for family court to consider it? And if there is no physical assault, then obviously there is no report. And then how do you even lay your case out that there was abuse going on here? And then, courts can look at it through that lens.
So, like Will said, emotional abuse can constitute violence as defined in the Family Law Act. I mean, there's a case called Menchella that our firm represented one of the parties, where text messages constituted abuse and what was sufficient evidence to ground an exclusive possession claim. So reports will be reviewed. Police reports will definitely be reviewed, but it's not the case or the situation that you need a report filed with the police to obtain an exclusive possession order or restraining order in family court. I mean, these decisions are based on affidavit evidence, sometimes tested by cross-examination, but again, that case involved abusive text messages that were sufficient to oust someone from the home to protect the children in that case. So, you don't necessarily need to have photographs of injuries, although, I mean, that would definitely be sufficient to ground a restraint, to form the basis of a restraining order.
Right.
And I think also, just to pick up on what Michael said, is there's different types of restraining order. There's a criminal restraining order under the Criminal Code of Canada, but there's also a restraining order under the Family Law Act. And the level of proof to get the two types of restraining orders is far different. You have to prove in a criminal court beyond 100% that this event occurred that mandated a restraining order. Under Family Law Act is simply the burden of proof. It's 50% plus one. And to add to that, a judge has enough powers under the Family Law Act to say, okay, we're not sure if he's been as abusive as maybe the allegations are, but you can't come to her home except to pick up the children. You can't go to her place of work. To structure a restraining order that provides the safety that a woman is looking for.
So I had another recent COVID-19 case or motion brought for exclusive possession, where in that case, my client had been assaulted over a year or close to a year ago. And the police were called. They were living in the matrimonial home together. Police were called, and he was criminally charged with assault and then was subject to interim release conditions or bail conditions that he wasn't to attend at the home. Once someone is charged criminally, the victim has access or access to the victim services and is sort of kept up to date. But in not all cases will you be fully kept up to date. In that case, she met with victim services months and months ago, and the idea of a peace bond was raised. I mean, a peace bond is basically there's no admission of guilt, but you agree to sort of stay away from the complainant for a period of time. This isn't from criminal court.
Right.
So she assumed that peace bond was sort of in existence forever, that it wasn't time limited. But in this situation, it was time limited. And she didn't realize that the peace bond obtained through criminal court between the Crown and the defendant had expired. And she learned just last week through her adult son that the peace bond had expired, and the husband was now intending to return to the matrimonial home after being out for a period of approximately a year. So in that situation, she immediately contacted me the minute she found out. She was a new client. I hadn't met with her before that. And in that situation, we again brought this motion for exclusive possession. And in that situation, the peace bond had expired, that there was no admission of guilt. And we didn't have, current evidence of any abuse because he hadn't been around her. The whole crux in that case was that because there were 3 kids in that house, that it would be effectively disruptive for him to then simply return, although they had a basement apartment and he was basically requesting to return and use only part of the home. But in that situation, the court was cautious, and the result was that he is to stay, or the result is that she has exclusive possession, and he can't now come near that property. It's not a restraining order, but he can't attend at the property, move back in, and then all the other issues of parenting. He hasn't had any contact with the kids since that time as well. All that then has to be worked out. But again, that's an example of a case where there's no evidence of any physical abuse, but the court in that case was concerned about the potential for conflict, in the presence of the children, based on his return. Yeah,
that's really great. And that actually is a perfect segue into the next set of questions that I had was, about custody and access. And we'll get into this, especially the impact on children of being exposed to family violence is huge, and we'll get into that in a bit. But before I do that, if you could just describe for everybody the difference between custody and access. A lot of people think sole custody means I have the kids all the time, or if I agree to joint custody, it means that the kids will be 50-50 with both parents. And this is something that I falsely believed as well in my time of going through all of this. So if you could just maybe, William, you can describe for everybody, how does custody and living arrangements differ, and especially when there is abuse involved, what are some things that the court looks at?
Sure. I mean, there's 4 different types of custody order. There's sole custody, joint custody, shared custody, and split custody. I know I said those very quickly. Sole custody, in all those arrangements, it doesn't mean that one parent is not going to see the children or is not going to be able to participate in their lives. It's just the extent to what will happen. Sole custody means one parent can decide, okay, the children are going to go to this school, they're going to have this person as a dentist, and I'm going to raise them in this religion. That doesn't say, well, I'm going to move from Toronto to Vancouver. That doesn't allow you that right, especially if they have access. Joint custody is you have to make decisions together. And what I tell a lot of my clients is you may spend a lot of money fighting over a label that's not necessary. If you have older children, let's say 13 and 11, then they already have doctors, they already have dentists, they already have orthodontists, and they're already in school. There's not really a lot of decisions to make for those children. So you can tailor an order to say, well, maybe there's no custody order, but in the event that the parties can't decide, you say they'll follow the recommendation of the doctor or the dentist. But if there's a decision that they can't agree on, then mom will have final say. You can put that in. Shared custody means the children are with each parent not less than 40% of the time. That has a lot to do with regards to support. It changed the whole support model. And then split custody is if you have 2 or more children, one child with one parent, one with the other. Very, very rare to happen, only if they're much older and the children can give that opinion. So, but in all those scenarios, the court will look to see, has domestic violence happened in the presence of the children? Are there any addiction issues? What's the suitability of accommodation for the parent that has seen the children? You can get everything from having a private agency supervise the access, tends to be very expensive, to government offices. They're not being run right now, but where you go to, it's basically a supervised visitation center. It's done at, sometimes a recreation center where somebody is watching the children and the parent to see how they're acting. Or maybe you're confident to say, okay, I don't mind you seeing the kids, but I want your parent or I want this mutual friend to be present. That's fairly common as well. There's also a lot of caveats put on access. If there's an addiction issue, no consuming alcohol or any form of narcotics or abusing prescription medication, 6 hours prior to the visit or during the visit. One of my clients, the father had a serious drinking problem, and we discovered that he was drinking. The 8-year-old boy revealed it to the mother. So I got an order last week. He has to get a device attached to his smartphone, and before his access begins, he has to start filming, and he blows into it to see whether or not he's been drinking. It's called SoberLink. And he has to provide that sample 4 times a day. And if he fails any of the samples or fails to give it to my client, then his access is suspended. So, and a lot of people say, well, I don't want my ex coming to my residence, that there's a great fear. Again, you can do it in a public place. Even with the pandemic protocol, you can go to a parking lot of a grocery store or some other public place to exchange the children. So there's a lot of safety precautions, but it is very rare to be able to have somebody get no access to the children at all. I've done this for 25 years, and I can probably say I have 4 cases where I was able to cut off parenting time completely. But what most people do, and if we're talking in the context of tonight, where it's the woman that is making the claim and the husband is the abuser, the first thing the husband is going to do is make allegations against the wife for the children, because the most important thing to a mother is her children. And we see this, and I know Michael and everybody else at my office has seen the same thing, where they say, well, if you leave me or you start something, I'm going to take the kids away and prove you to be an unfit mother. it's just, it's a threat that really shouldn't be believed, because especially
that's very powerful.
Right. But if that person's a stay-at-home mother and the husband is going off to work and he says, well, I'm going to prove you an unfit mother. Well, then did he call the Children's Aid Society before now to say you're an unfit mother? Did he put the children into daycare? Who took the children to their doctor's appointments? What would the doctor say if asked to write a letter, swear an affidavit? What were the kids arriving at school on time? Was their homework done? Did the teachers have any comments? It is a very powerful, but I don't think that threat really holds any truth, because what men love more than most is money. And they're concerned that when they lose custody of the children and when the wife leaves them, it's going to cost them money. They'll talk to friends, they'll talk to lawyers who say, you're going to pay child support, you're going to pay spousal support, you may have to get an alternate residence. And that's why they threaten the most powerful tool. The most powerful tool after physical abuse is obviously to make a threat about the children.
Yeah. Oh my gosh. I just got goosebumps when you said that. I remember in my time as well, my ex-husband did not want the custody. He didn't want to raise the children because that would require work, but he wanted to reduce any kind of child support that he would have to pay. And I was the one single-handedly raising kids for years and years. And now suddenly I was an unfit mother. And in his response documents, when I filed my court case, there were all kinds of silly examples that he had used, that I gave kids stale food and other things to prove that, or somehow portray that I was an unfit mother. And my lawyer then was like, this is gonna hold no ground. On one hand, he's saying, I'm okay with her having custody. On the other hand, he's saying that she's an unfit mother. So, but thank you for saying that. I think it's really powerful coming from someone like you, and that is something that a lot of men do. And you're right. It's simply a tool for control, but women get scared of that. Women often feel like, oh my gosh, like I'm going to lose my children, and then they will be vulnerable and kind of give in to stuff that they probably shouldn't give into.
But if I could just add to that, the courts are cognizant that this has happened, and child support since 1997 is governed by the child support guidelines. You look what somebody makes, you look at the table, they pay that amount. And it used to be that a lot of men would say, all right, I'll give you custody of the children, but I want to pay half the amount that I should be paying. And when a person applies for a divorce now, you have to say, this is my spouse's income and this is what he's paying. And if he's paying below the guidelines, there has to be some pretty strong reasons to why that's happening. You have to set out an affidavit, because the courts want to make sure that a person who's getting custody of children is not being blackmailed, not being coerced into taking less money.
Yeah. And there's also one quick thing on the children piece that I want to ask is, we see some cases in the media, like just last year or a couple of years ago, there was this father in Brampton who ended up murdering his own daughter because he was mad at the mom. So, until and unless those things happen, we never anticipate them to happen. So on one hand, like you said just now, William, that in your 25 years career, you've only seen 4 times when an abuser or a father has been, denied complete parenting rights. However, what about in cases where there is a threat of danger to children, but there's nothing proven yet, and the courts are mandating that, yes, the kid does spend time with their father, like in the case of that of Ria Rajkumar, who was that girl in Brampton, and eventually, she's found dead, and everybody in hindsight can say, oh yeah, there was evidence that he's an abuser. He was abusing the mom. He should never have been allowed to go near the kid, but he was. So, I'm just going to play devil's advocate here. Like, what do you think needs to be done to prevent situations like these? Or are there ways that we can mitigate that before tragedy strikes?
Yeah, I mean, what I tell judges is that children are not experiments. And so you have to do a subjective test opposed to an objective test. In other words, each case, you look at it on their own set of facts. And so what I will often say to a judge, maybe unsupervised visitation will happen in the future, but for the next 8 visits, this is what should happen. It should be supervised at a center. It should be supervised by a relative or a friend. And if that's done and there's certain safety precautions put in place, then maybe is expanded. If people are very serious. You can have what's called a Section 30 assessment done under the Children's Law Reform Act, which means that somebody, a specialist, either a child psychologist or psychiatrist, is going to interview the people. They are expensive. They're time consuming. A lot of people don't have the ability to get those done. There's the Office of the Children's Lawyer in Toronto, who, again, not as expansive as a private assessment, but they will go in and make sure that the concerns of the parents are met. So those are other tools that can help. Occasionally these tragedies do happen. They're few and far between, but obviously one is one too many. So all we can do is tell the story. And I think the problem is that a lot of times the lawyers don't spell things out. What the judges are looking for, they want a story to be told to them. They want a full explanation as to what's gone on. And when you lay that foundation and say, here's the history, and history is a way of repeating itself, that you can put those safeguards in place for the child.
Absolutely. You know,
there's also
yeah, sorry, go ahead.
Sorry, I was just going to add that there's also the Children's Aid Society. There's a duty to report in the legislation that, a doctor has a duty to report any concerns they may have with respect to abuse. So, I think, all the professionals have to be vigilant, and you can't anticipate everything. Like Will said, there are resources out there. You can contact the Children's Aid Society to make reports. Their mandate is to protect children. So they'll immediately do an investigation. They may close the file, they may not. If they don't close the file, they may take other measures. They may write a letter that they believe that the child is at risk of emotional or physical harm. They may ask the parents to enter into a voluntary service agreement so that their care of the children is subject to terms, and they sort of monitor it. So again, it's just a matter of being vigilant, and there's access centers, there's companies like Braden Supervision Services that supervise access out in the community and at home. So there's options and resources available. And like Will said, that you have to explain to the judge why and set out a plan of care effectively, right? That if there's going to be supervised access, it's not going to be a permanent solution, right? There's going to be a period of time where there's going to be supervised access. You'll obtain the supervision access notes, and then have a review with the court or something like that. Yeah. Just so the court knows that this is going to be monitored, and it may be that access is terminated, but there's going to be an evidentiary base created for the judge to review and to base his decision on, or her decision on.
And when is it usually when that the Office of the Children's Lawyer gets involved? I have a very close friend who just recently was going through a custody battle for her daughter. The daughter actually used to live initially with the dad because that was their arrangement, but then the daughter started to display signs of mental distress because the father was just, emotionally abusing the child and planting seeds of hate against the mother, and the poor kid was just under a lot of emotional distress, and she said, I don't want to live with my father anymore. And it went into a full year-long court battle, but eventually my friend was able to get her daughter to live with her. But that's, due to the Office of the Children's Lawyer being involved and interviewing the kid and the kid going into therapy as well. So what does it take for them to get involved, and how much of their recommendations does the court take into account?
Well, you first need a judge's order. And a judge won't rubber stamp, to use that expression. You have to set out in material why the Office of Children's Lawyers should be involved. In most cases, I would say both parties usually consent to it, but if not, you'll have an argument, and the judge will then decide whether or not this is a case to the children's lawyer. You then have to fill out a information form, which is probably about 20 pages long, and you have to submit that within 10 days. And if one party doesn't, they will not take the case. And then once both parties have submitted their form, the OCL will decide whether or not they will take the case. And unfortunately, budget constraints before COVID-19 were already meaning less and less cases were being allowed to go to the Office of Children's Lawyer. They'll usually want to see something unique about the case, but the intake forms are really important. And that's why we always review them with our clients before they send them in. We want to go through it and make sure that the story is properly told. So again, gets back to the point of making sure you relay the proper information to the OCL as to why they should become involved. I just want to back on something we talked earlier about, or I think what Michael touched on, and that is, I find a lot of people are ashamed about domestic violence, and if they are the victim, they shouldn't be ashamed. It's actually the other person that needs to be ashamed. And quite often people will not tell us the full story when they come in. And so we prepare their court material and an answer, then the other side profiles their answer. And then all of a sudden the victim becomes far more verbose and more open about the abuse. At that point, it's almost too late. It looks as though they are making up a fictitious story or embellishing the truth, because the argument is, well, why didn't they say that in the beginning? Yeah. So it is very important to be completely candid so you get all the information in. And what I tell my clients is I say, give me as much information as you can. If it's too much, if it's irrelevant, I won't include it. But I'd rather have too much information than too little information.
Yeah, you're so right. There's a big stigma around domestic abuse, especially, you know, when women are often blaming themselves for it because they've been culturally or societally conditioned to do so. They think it will appear on them as a bit of a failure, or they will appear as not strong enough that they tolerated it. So they carry a lot of shame, and that does come out in different ways. Thank you for pointing that out.
Well, my client, Sarah, just picking on my client who was stranded in the hotel. I mean, when she came into my office, she questioned herself. She didn't know that she was actually a victim of abuse because she was just so subtle and so just always there, and it would just sort of form part of her daily life. And it wasn't until the husband assaulted one of the children that she took action, because she just sort of put up with it like it was just a part of the routine. But once the child had been assaulted, then she fled, and then was trapped in that hotel until and a lot of people in her situation just don't know what their rights are. That's why it's important to, you know, find a lawyer who has specialty in the area, sit down, you know, for a consultation, a free consultation, whatever it is, sit down and understand and learn your rights, because, you know, you can be really harmed in a family court proceeding if you're not fully aware of the resources and what you're entitled to.
It's intimidating at best. And, you know, I want to pick up on one really good point you mentioned there, that women are not even aware of their basic rights. And that, I think, applies a lot more to women who are newcomers to the country, who are immigrants, who are coming from, you know, marginalized backgrounds, and they just are not aware, and they haven't been exposed. I was one of them. I came here as a child bride, and I thought for 10 years when I was married and living with him and his parents, I was being told that I would be deported if I left him because he sponsored me to the country, and I would lose my children because I don't have any kind of education or job or income. And if any of you can shed a light on that, if you see that as a pattern. And also the other point I want to ask, a lot of people that, you know, are immigrants and coming to this country, they also live in joint families. I had my in-laws living with me, and sometimes, you know, the husband may not be overtly abusive, but the abuse may be happening at the hands of the in-laws. And I know that is actually one of the questions that somebody asked in the Q&A box, that if the abusers are, and everybody is like, they are just emotionally abusive to the woman, and her money is being taken away from her, or she's not being allowed to go out of the house or make friends or meet people. It's a very constrictive environment, and she's just being criticized and broken down and being given false information or being made to sign things under duress. How and is that recognized in, you know, when things come to the point of going to court, that they're like, it's not maybe the husband that's abusive, but it's the family? And how do you even, again, tell that story?
Well, again, as long as your lawyer is made aware of that, a restraining order doesn't necessarily apply just against your spouse. It can be the extended family. And it can also deal with giving exclusive possession of the home. And I think a lot of people are under the misconception that, well, I can't get exclusive possession of the home because it's a rental. or the home is owned by my in-laws that don't live with me, or something along that line. The court is very powerful and will do whatever is necessary, first and foremost, to protect the children, but then to stop any abuse that's going on. So I'm sure Michael, like I, has received exclusive possession orders for apartments, homes owned by third parties, making sure that money is paid. Support orders in Ontario run through what's called the Family Responsibilities Office. They take quite often a few months to get up to speed. And so what some judges will do is say, well, I want you to make a payment to your wife of $5,000, and then starting a few months from now, then the support will stop, so that the Family Responsibilities Office can catch up. But they're really, I think that there's so many remedies available through the court to stop abuse, address abuse, whether it's financial or physical, that it's imperative that you do speak to a lawyer, because we can offer very good solutions. You know, if the abuse is so bad that somebody is scared, they say, well, if my spouse gets served with these court documents, I think they're going to kill me. You can go to court. It's called an ex parte motion, a motion without notice, saying, I'm not serving my spouse. I want an order throwing them out of the home, or giving me a restraining order, whatever you need. And if the judge feels compelled that there is a risk to that person, they will grant the order. Now, it's only good for 2 weeks. You have to come back to court within that 2-week period, but you can get these ex parte orders.
Mm-hmm. That's awesome. That's really good to know. And you know, to your point as well, like if the woman is not on title of a home, or she's not on the lease, or the home is, let's say, owned by the parents, and the woman and her husband are simply living there, what can be done? Like, does she have rights or any kind of recourse to that living arrangement or property?
So you have an equal right to possess the matrimonial home.
What defines a matrimonial home? Is it just yourself and the spouse, or also, like in my case, for example, the home was owned by his parents. It was co-owned by him and his dad. And then just a year before the separation, he got off title. And then, so at time of separation, even though I'd been living in that home for 10, 11 years, I was told that I have no recourse because he was not on title. And I know he did that deliberately. So can you maybe use that as an example?
Mm-hmm. Mm-hmm. Yeah, we had talked about that. I mean, the matrimonial home is the home in which you and your spouse were residing primarily at the time of separation. So where you were living was definitely your matrimonial home. And you had the right to possess that home, whether or not you're on title. I mean, ownership matters, but not in terms of the possession of the property. And you could have made a trust claim in that, because it sounds like he, in anticipation of the separation, fraudulently conveyed his interest in the matrimonial home to his parents to defeat your claim. So, that's what we call a fraudulent conveyance, potentially. So you could have brought an application to set aside that transfer as fraudulent. You could have made a trust claim in that property. It wasn't, and I had a similar case where my client was living with her in-laws and her spouse in a property, and she felt that she had no entitlement to that. And before she retained us, she had basically gave up her interest in the property and ended up in a basement apartment. And that resulted in a situation where the husband and the in-laws were alienating the children against her. And the children didn't want to go to the basement apartment. So all these issues are interconnected. And it's important to have proper advice right at the outset, because if you make the wrong move, or that could have a sort of a trickle down effect on all the other issues. Yeah. So,
and just if I could pick up on what Michael said, when you go to court, you have to swear what's called a Form 13.1 financial statement if you're seeking an equalization. And at the end of the financial statement, it says list of all the property that you have disposed of in the previous 2 years. And so in your case, Samara, your husband's interest in the home should have been listed there. And that then triggers the court. And if they're not truthful on those financial statements, you can serve a Form 20 request for information. And you can say, I want to see bank statements for the past 5 years, credit card statements, But the great one that I always ask people for, I want to see your credit bureau report, because I presume they're going to lie about everything. But if they sign an authorization for me to get their credit bureau report, or I get the original, I can see, well, here's an acquired from TD Canada Trust, or here's a mortgage that was registered. Then I know that there's assets there. We also have a private investigator company that does asset investigations. It's more expensive, it's $600. They'll locate any asset that a person has had in their name in the past 5 years in Canada. So that's sort of the last step, but put them to the task. Start seeing their financial statements. So when you see their pay going into their account every single month, yet you see big chunks of it being transferred, and you find out that transfers to the account owned by their parents. I mean, that again is what's called an improvident depletion of your net family property, and you may be entitled to more than half of what you have now.
That's really great. Thank you for pointing that out. And you know, when it comes to, you mentioned a little while ago about the role of the Family Responsibility Office. So can you just elaborate on that a little bit? What kind of how does FRO enforce payments and also enforce financial disclosure going forward? Let's say, you know, the court has settled, okay, this is the amount of child support, this is the amount of spousal support, but as we all know, child support it comes from the child support table, and that means you have to exchange financial disclosure. And if there is a complete breakdown of communication between the victim and her abuser, and it's just uncomfortable to do that, then how can FRO play a role there to enforce payments, and also like to make sure the payments are up to the level where they should be if incomes are rising over time?
So I don't think FRO will amend the support payments each year, but every order you get will say there has to be financial disclosure. And I've had a few cases where we ask for it, the other side won't give it, and I say, just to let you know, we're not acquiescing, we're not agreeing that you pay less money, but we're going to ask for it in 5 years or something, and the arrears will keep building. But what happens is every single order that's made in Ontario for support must go through the Family Responsibilities Office. You can opt out of it to say, okay, he's going to give me checks privately. But you fill out the form when you're in court, setting out where they work, all the details and information about them, and then they garnish his paycheck. Mm-hmm. And there's a massive fine if an employer does not allow the garnishment to be in place. So it's worked out very well. I mean, it is woefully behind the times. You can't get information online from your own account. So there's updates that are needed, but in principle, it's a great idea. Our firm has great relationships with the head lawyers at FRO, so we can usually get information very quickly. And as well, when somebody starts to default in support, so I have a case right now where the husband's 8 months in arrears of support, and we knew he was selling a property, so I got a judge to order back in the beginning of March that all the sale proceeds get paid into court. And so I now have $230,000 sitting there. And my argument to the judge is going to be, he's never made one payment voluntarily. He's made some other payments. I want that all paid to my client as security for support. So again, under the family law, there are these tools in order to make sure that support recipients are financially secure.
Yeah. Yeah.
And financial disclosure is crucial to all of this. And the court has the power, obviously, to make orders for disclosure so that child support orders are based on the payor's total income for support purposes. And like Will said, you can seek orders for security for support. You can seek lump sum support in rare cases where a clean break is needed. Lump sum child support is rare, but can be ordered where there's a pattern of non-payment. And there are sanctions for litigants who do not produce their disclosure in breach of court orders or in breach of the rules. Costs can be ordered against them. They can be struck out of the court proceeding, meaning the recipient can proceed without notice to obtain their orders they're seeking at uncontested trials. So the court has a lot of power to ensure that disclosure is being produced, and the FRO again also has power to, and their mandate is to enforce support payments. They can suspend driver's license, take away passports, garnish wages, and what have you. So But right, Will's right that they're not going to amend on an annual basis, but there's a provision in a court order that disclosures to be produced. And if it's not produced, then there can be sanctions imposed by the court.
Okay.
And I don't know, just to feed upon what Michael said, I mean, I have clients and they say, I don't feel comfortable asking my spouse for the tax returns. Can you get it? And I say, sure, we don't charge for that. I mean, it literally is a quick little email, and I have my clerk then feed it into the computer software we have, and we say, listen, your support's gone up by $30. Or I think 3 times since the guidelines have come out, the actual amount has changed. So again, that gives rise to the change. I get a lot of women that say to me, well, my husband's a plumber and it's all cash and we're not going to be able to prove it. And invariably, he will have applied for credit at some point. And they always lie on their credit application because they want to drive that Harley Davidson motorcycle or get that vacation property. And they'll put down the higher amount there. And you also look at the lifestyle. You know, if they say, well, we took a trip to Cuba every year and we go up north and these are the vehicles we drive, how can he actually be earning the $20,000 on line 150 of the income tax return? Support is not based necessarily on line 150 of a tax return. Sure, if you're an employee of a reputable institution, it is, but otherwise the court has broad discretion to impute income.
That's really good to know, because that is a question that that was asked to me prior to starting this. It was on my list. Like, what if the income is in cash? And also, like, what if let's say there's a case where the support is being paid, but for, let's say, 5 years there has been no financial disclosure, and now when you ask for the 5 years, let's say, notice of assessments, and you see, well, it should have gone up every year, but we're still at that static level of where the income was imputed 5 years ago. So does the woman have the claim to actually claim those arrears?
So that's sort of a case-by-case basis. It's yes and no. So I had a client who the wife hadn't done anything for 12 years. And he had voluntarily given his tax returns to her. He had voluntarily said, let's true up the amount of support, because they also dealt with extraordinary expenses, what we call Section 7 expenses, and she did nothing. So the court said, well, Mr. Smith did not have blameworthy conduct, and we're not going to go back that far. We'll go back 3 years from when the lawyer sent a letter. Mm-hmm. Where there are other cases where it's mandated that the husband must provide the financial disclosure and must true up the support. And there's a case from the Court of Appeal where it says a support payer is deemed to know the law that they must do it. In those cases, yes, you can go back. I did a case up to the Court of Appeal called Clark and Clark. And in that case, the court went back 10 years and adjusted support.
We talked quite a bit about child support. What about spousal support? And I know from my basic understanding that there are no table guidelines, but there are some guidelines. And can you talk about that a little bit, like the duration, the guidelines, the adjustment periods? What do courts look at when they're determining spousal support?
So we have the spousal support advisory guidelines. They're not legislated, but the Court of Appeal has endorsed them. So they're a tool that family lawyers use, and they set out a range of support based on certain factors: the length of your marriage, your age at separation date, the incomes, of course, of the parties, the ages of the children at separation date. So, I mean, spousal support is based on, there's different models. There's compensatory support, non-compensatory support. Compensatory support is based on, the roles you assume during the marriage, who was economically disadvantaged. I mean, if someone had stayed at home to raise the children, during a 25-year marriage while the other spouse was the financial breadwinner, then there's going to be entitlement to spousal support. So spousal support's based on the need and means of the parties as well. And some support might be transitionary support if the marriage is of mid duration. But the spousal support advisory guidelines set in a range of support as well as the duration, and it's all based on these variables. So, I mean, it'll change from case to case, but if you've been married for more than 20 years, you're likely entitled to indefinite support. I mean, if you stayed at home, raised the children, you were economically disadvantaged while through your hard work and support, the other spouse was able to maximize their income earning potential and advance their career, then there's likely entitlement to spousal support. You prove it, establish entitlement, then you move on towards duration and the quantum of support.
What about the age of the respective people? For example, I'm just going to use myself as a case study here, but I was married when I was 17 years old, and I was not allowed to go to school for a very long time, et cetera, and there was abuse. So in my case, because I was put at a severe economic disadvantage, even though I wasn't married for 20 years, I was 11, but there was some kind of meet there in order to warrant spousal support for a bit of time. Now, my income quickly grew after I graduated, but sort of what could spousal support look like in something? Can the court say, well, until she makes this amount of money, he will continue to pay on a sliding scale? Or does it look like this amount of time, this amount of money, and that's it? Or what sort of, if you can maybe give some examples of what these decisions look like?
Well, so it's a subjective test, and it really is a case-by-case basis, and a lot of it has discretion for a judge. But Samra, in your case, when you were here, and perhaps for some of the other viewers tonight, there are exceptions to the guidelines, and one of them is if a party immigrates to Canada to become married. So if one of your viewers today is in Canada, only been here 2 years, married maybe 2.5 years, and has a young child, in my mind, it's standard. In the old days, they would get probably little or minimal amount of support. But because they are in Canada, they might have a limited ability to work here. They have a young child.
Sometimes even language barriers.
Right. And when you run the numbers in the spousal support advisory guidelines, it may give a very low number. But when you add in the fact that that person emigrated and was sponsored, which, by the way, the sponsorship agreement says that they will make sure that person doesn't go on welfare. So a judge is more than happy to order spousal support opposed to somebody to be on government assistance. So it might extend it to be a bit longer. But certainly in your case, when you say, you're promised the ability to go to school, there is a compensatory element of support because you were raising your 2 daughters, as well as the fact that you lost the opportunity to contribute to a pension at work, lost seniority at work. All those things play in as being important factors. And what the court will often do is say, well, I'm ordering this for 5 years, and after that there can be a review, or come and see me, or this is what will constitute a material change which will stop the support. So what we're getting a lot of cases now is, if you talk about somebody where the support payer is a lot older, let's suppose they're a police officer or they're a teacher and they hit their pension benefit at an age well below age 60. Is it reasonable for them to retire? May not be, because of the amount of support they have to pay because children are about to go to university. So each case is unique on its circumstances. When I first started this 25 years ago, if somebody wasn't married for at least 6 years and never asked for spousal support, the pendulum now is completely swung the other way. I mean, as soon as a party is married, there is an obligation to pay.
There's a further exception involving disabled spouses. So if you're a disabled spouse and you're in an abusive relationship and say you've been together for only 5 years, if you're disabled, there's a Supreme Court of Canada case called Bracklow that I think the parties were only together for 6 or 7 years, and indefinite support was ordered because one of the spouses was disabled and was incapable of ever becoming self-sufficient. So even though it was a relationship of a short duration, indefinite support was ordered. And like Will said, judges, you have to seek an order or seek spousal support through agreement. And some agreements will have sort of a spousal support order for a certain period of time, subject to review or variation in the event of a material change. And then parties may agree to have a drop down or a step down in support, depending on the nature of the circumstances of the case. But before a spouse is able to obtain a court order, the spouses, the payor, should be maintaining the financial status quo pending an agreement between the parties or pending a court order. There are in some cases, there's a separation and then the payor just terminates the financial status quo, leaving the other spouse, dependent spouse, without funds. to retain a lawyer to meet her monthly expenses. And in that situation, that's a situation of urgency. That would warrant potentially an urgent motion, which is an attendance before the judge to ask for a support order on an urgent expedited basis, pending, and there's a process in court. You're supposed to start a court application. The other side has 30 days to do an answer. Then you go to what's called a case conference attendance with a judge, where the judge attempts to narrow the issues, but nothing substantive typically can happen. And then you can bring your motion for support. But where someone has terminated the financial status quo, leaving someone completely in dire straits, there is a resource available. There is the option of bringing this urgent motion to the judge to ask for some relief on a temporary basis.
That's exactly what I was, my next question was, like, if let's say, the court date is set out 30, 60 days, whatever from now, but like what happens now in the meantime, like,
Right.
Until child support is determined, until spousal support is determined, and, if a woman has no money, then it's good to know that the status quo continues as it is until then. So my next question is really about, that lawyer-client relationship. Like, obviously you two are very knowledgeable and you've seen this over and over again and very comprehensive, but I'm going to ask you to talk a little bit about legal aid first. And a lot of women, they have myths on, whether they can change their lawyer or not, or if they can even pick their lawyer on legal aid. I know it all seems so intimidating to me when I was going through this 10 years ago. So when you are looking for a lawyer, whether you're on legal aid or not, what kind of questions do you ask? What kind of information are you supposed to even get? Because not every lawyer is the same. So first answer that, and then I have another question that I'll segue into that afterwards.
So I think it's better to go to a firm where there's more than one family lawyer, because at least that way, the lawyer's bouncing ideas off of another lawyer at the firm. And quite often, like if I'm stuck in one court or if I'm away on vacation, I'll have Michael do work on a file of mine. He can cover for me, and vice versa. If you go to a sole practitioner, that's not possible. Look at the lawyer's website and see what level of experience they have. You may even want to, there's a website called Canly. You may want to type in the lawyer's name and see what sort of experience they have as far as doing trials. There's nothing wrong, like you have to make sure it's the right fit for you. So there's nothing wrong with asking the person, say, do you practice exclusively family law? It's become so complex that it's better to say, yes, I only do that, opposed to saying, well, I do every sort of law there is. That to me is a dying breed of individual. There's very few of them left, especially in the GTA. And I would have a little bit of hesitation with somebody saying that. I also think it's important to know who's preparing the material. Is their clerk or secretary preparing the material? Will they meet with you on weekends? Will they meet with you on evenings? How are they able to accommodate your schedule? You also want to know what sort of courtroom experience they have. A lot of lawyers don't go to court. They'll say, well, I'll try to negotiate a settlement for you, but if I can't negotiate it, I'm going to have to send you to somebody else, which means then we don't take legal aid, but the limited knowledge I have is that you need permission from the area director to switch lawyers. It becomes a lot more complicated. A lot of people as well may not need legal aid. It's worth calling a firm like ours or another big firm saying, I don't have any money right now, but my husband and I own a house together, or there are some assets, and we may be able to work on an arrangement whereby we say we will defer payment until support starts to flow or until money becomes available, as long as fees can be secured. I think a lot of people get scared as to how much things are going to cost. An actual true stat for Ontario is only 2.6% of family law cases go to trial. The odds of your case going to trial, to anybody that's listening, is pretty remote. And judges will try as hard as they can to get a settlement, because it's just, there's so few judicial resources. And that's even going to be more true when the courts open up again. It's scheduled to be June 2nd, but who knows if that's going to happen. So they'll really push hard for a settlement.
Yeah.
No, I echo what Will has said. I mean, I think you want to have a firm that practices exclusively in family law, because family law is changing on a daily basis. Cases are always coming out, and the law is always evolving. I think that there's a question I saw about sort of the, what is the impact on the amendments to the Divorce Act. I mean, that's an example of the law changing, and you want a family lawyer who's up to date in the law, and having a firm approach, I think, can assist with fees too, because we have junior associates at our firm that their rates are lower than ours. We work as a team, so they could, draft certain parts of the file for our review to keep the cost down, et cetera. So.
And it's great to know that there's a provision of working on an arrangement that, when the money comes in, then the legal fees can be paid out, because that's a big barrier for a lot of people who don't have income, and they are stuck in the legal aid web. And oftentimes, I know that my experience with legal aid was actually horrible, and my lawyer hadn't even served my ex-husband with the papers for 6 months until after we'd filed the papers in court. And he just kept saying, oh, these things take time, these things take time. Meanwhile, they were drawing the income from legal aid for hours billed. So there are all kinds of horror cases that we all hear. So it's good to know that, reputable firms are out there and who are aware of this, and they are open to working on these alternative arrangements.
I think a lot of times, I know Michael and I, we are cleaning up messes created by other lawyers, and we take over files to undo what should have been done to begin with. And it then gets far more complicated and far more expensive. So there's nothing wrong with reaching out to our firm, sending an email. And I think most of the lawyers at our firm will certainly arrange for a 30-minute to 1 hour phone call or a Zoom meeting to see what can be done.
That is the perfect segue into my final question before we address some of the audience questions. How long of a recourse does somebody have? Like, let's say if, someone has gone through the whole divorce process, they've settled, and at that time they didn't have the information and a good lawyer to give them that information. So they did whatever they thought was, they did whatever they were advised to based on that time. But now, they're like, well, that was the wrong decision. I was entitled to so much more. And they speak to somebody like you, and they're like, yeah, you absolutely were entitled to so much more. How far back can you go to clean up some messes, as you mentioned, made by other lawyers, or the people that have just short sold themselves? Like, how long of a recourse do they have, or if any at all?
Well, I think there's limitation periods associated with trust claims. You have, or property division, you have 6 years from the date of separation to seek, or 2 years from the date of divorce to make a equalization claim. I think you have 10 years to make a real property trust claim, 2 years to make a trust claim in other assets, business assets, pensions. So there are some limitation periods, but there's no limitation period on support. But I mean, sometimes people enter our office, and like Will said, we are cleaning up messes, or we're trying to rehabilitate people who unfortunately, consented to horrific orders and then can't comply with them, and then they find themselves in breach of orders. And so, I mean, if there's an agreement that was prepared that was deficient, or that say, for example, you released your claim to spousal support, I mean, you have other remedies in that circumstance, but in a lot of cases, there's time, right? It's not fatal what has happened previously. It's just a matter of taking corrective measures and trying to get the case back on track.
And speaking to somebody like you, I think, is the first step to do that.
Yeah, if I could just add to what Michael said, if you get an answer that you don't necessarily trust with a lawyer, call a second one. Get it. It's like if you go to a doctor and you don't like that opinion, people always go to a second doctor, or a lot of times go to a second doctor. So, I mean, what if there was fraud? Then that extends the limitation period even more. So if you speak to somebody and you don't like the answer, then call us or call somebody else. And if we think the first lawyer was negligent, we may send you, we don't do solicitor negligent work. We may send you to somebody else who does negligent work.
Yeah, absolutely. Thank you so much. This has been extremely helpful. I'm going to now turn to some of the audience questions. I know I did share some of them during our conversation, and I know, Michael, you've been reading along as well. Somebody just recently put a question: what is the relevance of a child's testimony in domestic violence cases?
Yeah, I saw that.
And maybe that is a criminal court question, but I mean, at least when it pertains to family law, if there's some kind of a weight given to children's opinions and testimonies?
Well, I know another attendee had asked about or mentioned that the Office of the Children's Lawyer now also offers voice of the child reports.
Mm-hmm.
So, and Will had mentioned earlier that there's the option of obtaining a private Section 30 custody and access assessment. These are tools used to ascertain the views and preferences of children. So that's sort of how you obtain the evidence of children in family court cases or trials. And where a family court case involves domestic violence, if the children witnessed abuse, those observations may be found in a voice of the child report or a Section 30 assessment. And, violence to a spouse is relevant. It's a factor set out in the legislation. It's a factor and relevant to the issue, to the parenting issues before the court. So that's how you would obtain the evidence, and it is relevant evidence in a family court case.
Yeah,
And does the age of the child matter over there? I guess the older the child is, the more weight their testimony holds, I'm assuming?
For sure. I mean, sometimes if a child is so young, you won't even get a voice of the child report. I think the youngest I've gotten one for is age 6, and that's because he had an older sibling as well. But, we have quite often used the criminal transcripts or criminal proceeding within the family law proceeding. I saw one of the questions when we were here about getting criminal records. You can get an order for that. Otherwise, they'll do it on consent. The children's lawyer, the private assessor will often get the criminal records. You can't get it without the other side's consent.
Yeah.
There's also the Victims' Compensation Board. I remember I had a file where my client obtained an order for damages or an award of damages as a result of abuse she had suffered. And that decision was actually relied on by a judge in the Newmarket Court in ordering spousal support against him.
Somebody also asked if how do these laws differentiate? Does it differentiate from province to province a lot, or is it primarily similar across Canada?
Well, with the exception of one lawyer in our firm, we only practice in Ontario. So I think it's fairly similar concerning parenting. Property law in Alberta and BC is a little bit different. Use the value as the date that the final deal is done, not at the date of separation. I would think it's fairly similar, but we've often, if somebody moves to another province, I've often sent them to another lawyer. So I know Michael did a case recently, I think in Nova Scotia, New Brunswick. He might be able to comment further on that.
That was a child abduction case, and that involved the Hague Convention. But yeah, I think I agree with what Will is saying. I mean, we don't practice. I did have a New Brunswick case, but their practices there were similar to Ontario in terms of how they deal with child abductions.
Yeah, and somebody has asked this question that she's not willing to go to a shelter right now, and they have no place to go. And I just want him to stay away from me physically and mentally. Is that possible? And how expensive is the entire process? So maybe just shed light a little bit on average, in cases where there is domestic violence involved and there are custody and access issues, what kind of financial, obligation are we looking at? And yes, there are different ways of doing it. Like you said, there are junior lawyers and in your team, and obviously you can make arrangements of taking money when property is divided, but just to give people a little bit of a general idea of a range.
It sounds like that attendee is in the same house with the other spouse and would like to resolve it by way of a separation agreement, but doesn't have the resources, but wants him to sort of stay away. Mm-hmm. The option in that situation is to keep talking about referring to exclusive possession, but to ask for an order that can be removed, or you can ask that, that you have exclusive possession of a certain part of the home and they have exclusive possession of another part. I mean, it's difficult to deal with that in practice if someone but it's a court order. If someone then breaches it, then you have recourse. You can go to court to seek sanctions. it's always a difficult situation when spouses are stuck in the home, because the matrimonial home is typically, you know, the worst asset of the family, and especially in a time like this. I mean, I have a situation where the children are with my client primarily, and he's not agreeable to facilitating access because the other spouse is in a shelter, and there's been community spread in the shelter, and COVID-19 has just created, you know, difficulties here, because the option of a shelter is potentially not an option because of community spread, etc. So,
and they're full. They're absolutely,
they're full. Yeah.
they're full. They're full with long waiting lists, and it's not like they can just throw a few extra beds in there like they normally would because of the social distancing measures that are in place. Absolutely. There's actually a question. It's more of a comment, but it does spark a question. Somebody has written that my relative got divorced in 2012 by signing documents. She was ostracized because she changed her religion. She had to leave her children for that same reason and moved to India. She got very little, and she's still struggling financially. So I know definitely that there are a ton of cultural pressures in certain communities, and certainly I come from the South Asian communities, I can attest to that. If there are issues like that where, you know, there's been a lot of family pressure, and sometimes, you know, the woman's her own family goes against her, and the mental pressure is so much that even if you have the best lawyer in the world who's giving you all this fabulous advice, you just feel completely bogged down by everybody around you telling you to, like, you know, like, no, you don't want to do that to him, and all of, like, I know certainly I was in that boat too. So if a woman does sign off on documents because of the backlash and the cultural ostracization and marginalization that she experiences, and now she is in very dire financial circumstances, and sounds like this person is in India, you know, again, back to the recourse question, and, you know, hopefully in time, as she realizes, oh gosh, like, you know, I was completely
a raw deal.
yeah, exactly. I was given the short end of the stick by everybody around me. You know, what can someone like her do? Like, especially if she's not in the country?
You know, right. I mean, she could potentially, I'm not sure what she signed, but she could seek to set aside or I don't know what she signed. If it was an agreement, she could seek to vary it or attempt to set it aside by, you know, proving material change in circumstances or something of that nature. But she, you know, if there was a trial here, I mean, if there was a trial, then maybe she could participate by Skype or something, but typically the parties have to be here for certain court appearances. But it sounds like, you know, she would have to move to attempt to vary whatever agreement she signed at that point.
Yeah, the problem that she faces as well, I mean, I know all the lawyers in our office, we say, well, if we were representing the other side, what would we do? And in that case, she's a non-resident of Canada, presumably with no assets here. I'd be asking her to post security for costs. And if she can't post it, then her case is going to go nowhere. It's tragic to see. I'm sure that she was coerced into signing something, but the fact that she doesn't live in Canada right now is a huge hurdle.
Yeah,
I can imagine. Yeah. And also, you know, we talked about the assets quite a bit, but how is debt handled? So, for example, you know, the husband has racked up the wife's credit cards and everything because he had access to everything, and he was the one who was controlling all the finances. This is something that, again, happened to me. My husband had maxed out all my credit cards, all my line of credit, and eventually coerced me into signing a proposal. So I mean, I paid everything off, but I've heard from a lot of women who are in these situations that I'm now divorced or separated, and I'm under so much debt that it wasn't even my debt. You know, he used all my money because I never had access to my money, and because I was being abused. So how is debt handled in those cases?
Well, it's handled the same way, with some exceptions, as the assets. You're meant to divide all the assets, and you're meant to divide all the debt. But if somebody, let's suppose the husband has been taking large sums of money and going up to Casino-Rama and blowing it, there is provisions within the legislation to say that that person is solely responsible for that debt. So the idea is that you take all the assets and you subtract the debts, and hopefully you're in a positive position. So there's money to pay off all that debt. But back, let's say in about 1999, 2000, which was called the dot-com boom, you had all these people that were being given these options in these dot-com companies, and then they were splitting up afterwards, and the shares weren't worth nearly as much as they were on the date of separation. And I'm not even talking about somebody racking up debt. They had these huge assets that were just an asset on paper. Well, these guys ended up declaring bankruptcy. In 2008, when the stock market crashed in the fall, that's when you had a big fight as to what the date of separation was, because the people that had assets that got devastated in the stock market correction would say, well, we separated in November. And the other side would say, no, we separated in August. So the debt is meant to be divided. And somebody such as you or any of the other viewers tonight should not think that just because the credit card, the line of credit is in their name, it's their debt, it's to be shared.
It's to be shared. And what if, again, it was used without her consent or without her explicit, rational consent? I mean, the consent is there because they're being controlled. Is there some provision where the judge might be able to say, well, you used all these, you're the one who incurred all this debt in her name because there was abuse involved, and is there any way to get off the hook from that?
If he used the money from the line of credit and credit cards to support the family unit, so he used it to buy clothing, food, pay rent, etc., I don't think it's a very strong claim. Yeah. If they use that money to go buy a house for the parents, then absolutely there is.
Yeah. Okay. Yeah, that's good to know. Just going to do a final roundup. Anyone else have any questions? Please type them in the chat box, and then we'll definitely go through them. And
Samara, someone had asked about what the impact on the amendments to the Divorce Act is going to be. Mm-hmm. How will custody and access change with the new Divorce Act? So the amendments take effect in July of this year, and the Divorce Act now has removed, they've removed the terms or the labels of custody and access, because there's a Court of Appeal decision that speaks to this, that these are labels that parents are now attempting to win, or it creates this battle between parents. And now, rather than including the tag of custody, we have decision-making models. Who should have, like Will went through sort of the different models or the different types of custody. So now we're going to be using the language of decision-making, and rather than access, we're going to be using the term parenting time. And there's new provisions. There's more provisions, I think, relating to domestic violence to help protect victims of violence, and then also additional provisions on relocation or mobility cases. If you're asking for an order to relocate a child, there's explicit factors that was set out in a decision called Gordon and Gertz of the Supreme Court of Canada, but now it's enumerated right in legislation. So we'll feel the impact of that effective July, but the big component of that is that we've removed those labels, that now it's more of a decision-making model versus parenting time as opposed to access.
Yeah, that's good to know. Somebody has asked if the woman has no status in Canada, is she eligible to get the child tax benefit for her child that is a Canadian citizen? I mean, this might not be a family law question, but
Well, if she's filing a tax return, which if she doesn't have status, I don't know if she is, but in order to get the child tax benefit, you have to file a tax return, even if you have zero income, to show that you're the primary custodial parent. So, that's the main factor there. I mean, there's some other good questions. Like one person's asking, does domestic violence case suitable for family mediation? Absolutely not. You have to sign a domestic screening form, and if there's been domestic violence, there's no way it should be done. It should just be a negotiation between lawyers, because you don't want them in the same room or the same building. And if not, then off to court you go.
There's someone who said, where can immigrant women find information about lawyers like you? Do they have to go through legal aid first and then find you? So I think you did answer that question a little while ago, but I'll just reiterate it and then you can add, is that, you know, you don't have to be a legal aid client in order to work with firms like yourselves, right?
Yeah, I mean, the other thing too is if they have access to a computer, when the libraries open up again, they can go to a library and Google our law firm name, MacDonald Partners. And there's a lot of really helpful links. There's a lot of good articles there and resources that will sort of set out your basic rights. If that availability doesn't exist, then if you go to one of the local courthouses, there's the big one here, Ontario in Brampton, or in Toronto, there's the one at 393 University. And there's a bunch of brochures there. And there's also lawyers there, what's called duty counsel, they'll speak for free. And then, you know, you can decide what route you want to take.
Yeah, absolutely. And this is a really interesting and important question, I think, pertaining to what's going on right now. If a person loses his job and is unable to pay spousal support, what recourse is available for the victim, especially these days, since many are losing jobs because of COVID? So if the support payer loses their job because of COVID, but they are getting the CERB or employment insurance or some other income, how does support change?
So I think this is going to be the new wave of COVID-19 cases. Right now we're dealing with the exclusive possession cases, the parenting, because a lot of, you know, some parents are withholding access because of concerns with COVID-19. And now we're dealing with clients who have been laid off or business owner clients who've had to, you know, lay off their employees. So, I mean, we're figuring this is developing, but you're right, there's government programs available. So I have a case right now where my client works for a university and he's been told that they're cutting his pay by 25%. So there's an interim separation agreement that sets out the spousal support and child support he is to pay. And he simply can't do it anymore because of his income, because of the income level. And we've attempted to obtain the consent of the other side to just simply agree on a new amount. And in that case, there's a jointly owned property that needs to be sold. So in that situation where, you know, we are going to bring, under the COVID-19 protocol, we're going to bring a motion to set the new support amounts. And the Family Responsibility Office right now is not, I believe they aren't following through with notices to suspend driver's licenses, et cetera, during this crisis. But in some cases, there has to be a reduction in the support because it's creating a very financial dire situation for certain payors. So, but you're right, there has to be a calculation. You have to set out in your material what you're entitled to. You have to show proof that you've actually applied to the government benefits, and then run a new calculation based on the new income level, and then go to court, bring a court through the protocol, which can be done by conference call or Zoom, depending on which courthouse you're in.
Great. William, do you have anything to add to that?
Well, just on the other side, if I'm representing a support recipient, I would probably write to the payer and say, listen, your pay first got affected end of March, and if we're going to go back to normal in June, why don't we just do a recalculation? Why don't you keep paying? Because a lot of these, if you can show that they work for some sort of company that will be up and running fully, and there's a 2 to 2.5 month suspension of their pay, and they have these benefits, the court might be a little loath to change their support. But I represent a gentleman who's a lawyer at a big law firm, and he's not getting any pay for the month of April, and his pay was cut 90% for the month of March, and he just cannot pay. So again, in that case, like Michael, we'll move for a variation.
Yeah.
Great. Messi asked this question: how about managing joint property if the other party is out of the country? So she has been divorced for 3 years, and her ex is refusing to respond to emails, and he's not even allowing her to sell the house or rent it out, and he never contributes. So what kind of recourse does she have there?
You get an order dispensing with his consent. If he's not in the country, you know, the judge is going to presume that she wants to maximize the money for the property, and she will simply say, I'm trying to dispose of this property to a bona fide third party. I'm not trying to sell it to my brother, but a legitimate purchaser. An opinion from the real estate agent as to what they'll get for this. A judge will dispense with the necessity of the husband consenting to the sale.
Okay, yeah, because as she wrote that he's not paying the mortgage either or contributing anything. So, okay, great, awesome. And I'm not sure if I've missed any questions. I think we pretty much went through most of them, unless you spot any, Michael.
No, I think
somebody asked about businesses. So we talked about financial assets when it comes to like personal assets and things, but what about if you co-own a business together? How is that usually divided, especially if they're, you know, they've been running the business or they own share, like it's a private company, it's not a public company, or, you know, they like, how does that work?
So, I mean, there might be a shareholders agreement that says how they're to be divided. One party may be acting inappropriately with the company, so then you have to, under the Ontario Business Corporations Act, bring what's called an oppression remedy. You may need to get a court to make an order that they cease and desist taking money out of the company or how they spend it. If it's agreed that the husband is going to buy the wife out of the business, you may need to get it valued. You will then have to retain a charter business valuer to determine what the company is worth, and how the payment's going to be made, and at the same time, what will his income be for support purposes when he buys the business out. A lot of people think, well, I'm buying the business out so I don't have to pay support. That it doesn't work that way. Even though they're buying the business out, for sure child support may well be spousal support as well. It just depends of the volume that the business is doing and what its income is.
Great, thank you. I think we've pretty much gone through all the questions now. I just want to do a quick roundup and ask both of you for some of your final thoughts that you might want to leave our audience with. I know we covered a lot of ground today, and for everybody on the call, I will be posting a recording of this session on YouTube. So if you want to go back and revisit something and you just want to listen to it again, or there are some specific things that you are interested in, please watch it, and all the links will be on my social media. But if, you know, parting words, Michael and William.
Yeah, well, go ahead, Michael.
Okay. My parting words, I guess, are know your rights. You know, there are resources available to you. Our firm, MacDonald Partners, we are available. We're up and running during this pandemic. We're deemed an essential service, so we're fully operational remotely, and we have a sort of a volunteer skeleton staff downtown. But I think it's really important to, you know, have a consultation to fully, you know, to get a sense of what you're entitled to, what resources available to you if you're in an abusive relationship. It's so important for the sake of your children to seek out assistance and just know that there is help out there.
Yeah, I just 100% what Michael's saying is correct. I also want you to remember that there's no such thing as a bad question. You know, you may think that it should be obvious to you, and it's not. You should feel free to ask any sort of question you want. You also must remember that you should not be ashamed of your situation. Nobody should put you in that situation. It is your rights within this country to walk away unscathed from an abusive relationship. And finally, if you have somebody that's going to try to guilt you to stay in that relationship, the example you're setting for your children is to your daughters, it's how women should be treated, and to your sons, that's how they should treat their spouse. And that is completely wrong, because as society evolves more and more, you're going to find that your sons are going to be getting arrested for abuse, and it's just not appropriate. And kids are far better off in two separate homes when they are away from the abuser.
Thank you. Oh my gosh, goosebumps and almost tears in my eyes. Thank you for saying that, William. It is
well said.
Very well said, and such a powerful note to cap off our session on. Do not tolerate abuse, do not accept abuse. And so many people, so many victims that I've talked to stay because they think it's the best thing for their children to give them a two-parent family. Nothing can be further from the truth. And I myself as a mother, the only regret I have is I wish I'd left sooner for the sake of my children, because the psychological trauma that my children experienced from being exposed to that abuse day in, day out has been very detrimental. But we're in a good place now. And the only advice I'd give to people out there is do not tolerate abuse. You're in a country where you have laws, where you have people like William and Michael and others who are willing to help you out, who are in your corner, and use them, and know that you have the power to walk away and be safe and be in a good place and build a new life after.
Thanks very much for inviting us.
Thank you for the opportunity, Samra.
Thank you so much. I really appreciate both of you joining, and I hope to keep in touch. And thank you for all of your wisdom and advice and your time. I'm absolutely sure everybody on the call is extremely grateful, as am I.
Yes, thank you to all the attendees. I see messages being sent.
Yeah, feel free to reach out.
Check out the website. It's great.
Absolutely. I will post the website when I put the video up. Thank you once again, and have a great night, everyone.
Yep.
Thanks, everybody.
Okay,
Good night.
bye-bye.
Stay safe. Bye-bye.